The state of California, through the Ninth Circuit, has allowed the sensitive areas part of the SB 2 anti-gun bill to go into effect. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms, your NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like channel-like content, what I do here, you can support me with the link. Everything is appreciated. My PSA for my Connecticut residents: if you plan on getting your Connecticut pistol permit, please get the training done before July 2024, because then after that, the training becomes longer, harder, and more expensive to basically disincentivize the law-abiding public from getting a permit in order to purchase a firearm. If you have your permit, watch that expiration date. Do not let it expire. Do not rely on the state to send out that renewal notice. But let's talk about this. Now, this has been literally a legal ping pong match concerning California's SB 2. Now, this is centering around two cases, Carolello versus Bonta and May versus Bonta, which is challenging California's new restrictions on where a person can carry a concealed firearm. This is reflective of what New York and Connecticut did by basically abolishing NRA certification as a required training to get a concealed carry permit. California followed suit by doing the same thing, but on top of that, they've now incorporated what they call sensitive areas. This is something that also New York did, where they listed a whole range of places where a law-abiding person cannot carry a firearm. Now, Judge Cormac Carney consolidated the two cases and claimed that they were both unconstitutional because they did not stand up to the written language of the Second Amendment and its historical context. But the state of California, the AG, ran to the Ninth Circuit to get a stay on that ruling so that the law could go into effect Monday, which is January 1st of this year. I want to come into here. Last minute stay allows California's new gun control law to go into effect. The Ninth Circuit Court of Appeals has given California's new concealed carry law a new lifeline. The federal court has administratively stayed a preliminary injunction that was issued by a district court that would have blocked the Golden State expansion of gun-free zones, making most of the state a sensitive area, which basically means you technically can't even really conceal carry a gun, is what it comes down to. You have to leave your house with your gun, go to a place where you know it's not a sensitive area, and come back. Because if you venture into any of these areas that they claim are sensitive, you're in trouble. The law, known as SB 2, went into effect on Monday after a last-minute reprieve by a 3-panel on Saturday. It expands sensitive areas where guns are banned to most locations in the state, including parks, playgrounds, public events, libraries, and 22 other places that California decided must be protected from lawful gun owners. It was passed after the Supreme Court issued an opinion stating that all states must become shall issue before the Bruin decision. Much of the state was may issue. Now, there's a listing of all the people, all the plaintiffs that sued over this law, and there are the two cases that I referred to, and the judge, of course, so I don't need to repeat myself on that. But to get a preliminary injunction, the plaintiffs bringing the challenge must prove they are likely to succeed on the merits of the case, even though Bruin kind of destroys that. Judge Carney could not find any historical analogs for the restrictions California wanted to enforce in order for a gun law to be constitutional. It must be consistent with the text, tradition, and history of the Second Amendment. Judge Carney ruled that SB 2 was not. Okay. California's Attorney General, Rob Bonta, celebrated the last-minute stay. He claims the law will keep the areas listed in the regulation free from guns, because criminals are really going to follow this. Yes, it's just amazing. We're going to pass a law that the law-abiding will follow and then make a ridiculous claim that this will keep these areas free from guns. It's so backwards. It's frightening. He didn't address the fact that most mass shootings take place in gun-free zones, which is a fact, or acknowledge the defensive uses of firearms greatly outweigh those used to injure or kill innocent people. But they don't care about that. They don't care about that. It's not about your safety. Quote, this ruling will allow our common sense gun laws to remain in place while we appeal the district court's dangerous ruling, Bonta said. Californians overwhelmingly support efforts to ensure that places like hospitals, libraries, and children's playgrounds remain safe and free from guns. Delusional. It's a delusional statement. But many in the California gun community don't know of the Ninth Circuit's last minute decision, meaning they're unknowingly breaking California law. Yeah, that's unfortunate. Now, I'm going to go ahead and come out of that. Now, this happened in New York. New York, all of a sudden, especially the 5 boroughs in New York City, they all of a sudden, after Bruin, constructed all these sensitive area places. Judges in district courts have shot those restrictions down, even though New York State is still trying to push them through. Now, I want to come here because when I say delusional, I want to bring up Newsom's response to this, because once again, it's devoid of reality. But in response to the Ninth Circuit stay, California Governor Gavin Newsom stated, quote, this ruling will allow our common sense gun laws to remain in place while we appeal the district court's dangerous rulings. Californians overwhelmingly support efforts to ensure that places like hospitals, libraries, and children's playgrounds remain safe, free from guns, which is pretty much what Bonta said in his statement. It sounds like these guys kind of had a template for this. But I always ask the question, are these people, I'm talking about especially those liberal leftists in these states, are they really that delusional? Is there a lacking of common sense when it comes to these kinds of things? How does telling a law-abiding public what they can and cannot do is going to make anyone safer or keep an area free from guns when criminals, and California is literally becoming ground zero for violence? How is this law going to prevent that kind of violence from happening? It won't. Anyone with any damn bit of common sense knows that this is not going to work, that crime will continue. They need this violence to keep pushing more and more gun control. Every time there's a shooting in a gun-free zone, they say, oh, we won't address the fact that it was a gun-free zone. We won't even acknowledge that little problem. We're just going to make gun bans against the public. And it's always backwards and plainly ignorant. But let's be clear, they're not stupid. They know exactly what they are doing. They know exactly what they're doing. They're using violence, specifically gun violence and crime, to push laws against people who don't commit these acts. Because they never, name one gun control law that we have seen in the last 5 years that has addressed crime. Not one of them does so. They come out with 80 pages of a new law, and maybe a paragraph actually talks about actual crime and criminal activity. This is just another step, and of course, it's going to move forward. It's going to end up at the Supreme Court at some point in time. But it just amazes me how clueless. But they're not. I can't say they're clueless. They're not. This is a specific agenda that they're pushing here. Don't think they're stupid. They're not. They know exactly what they are doing. They're making it impossible for the law-abiding public to purchase firearms, to own certain firearms, and to be able to carry firearms to protect themselves. Like I said, this sensitive areas law, pretty much you can't carry a gun anywhere unless you're going from your house to another friend's house who happens to be a gun owner too. Beyond that, you're basically stuck. You can't leave your house with a gun, and that's exactly what they're trying to do. It is frustrating and damn disgusting what they are doing. Once again, these court cases are dragging out. And I've said this before, they are pushing these things into longevity in the hope that the Supreme Court at some point, some of the more conservative members will leave the court, and hoping that they have a liberal president, a Democrat, who will appoint people who will rule in favor of pro-gun bans. That's really what it is. But it's disturbing, and you just really scratch your head. But the problem is is that other states are watching what California is doing. You ever notice? It's almost like I've said it before, a template. When one state does something, another anti-gun state does the same thing. Okay, New York did this, and now California is attempting to do it. I suspect, and I know I've said this before, but don't be surprised for you Connecticut people. Don't be shocked if Lamont goes out there on the floor again in front of all the cameras and says the same thing he said last year. There are too many damn guns in this state. Too many legal guns and too many illegal guns. And we need to do more. Don't be shocked. This has nothing to do with your safety. This is literally a way they are undermining the Second Amendment. That's what the goal is. That's what they're doing. And that's what these things are all about. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I will see you on the next one. Peace.